this has been a very tricky one, police misconduct. But I believe the time has come for the public to have the right to know how their officers are performing. And that, of course, affects all of us.
I'm Justin Silverman of the New England First Amendment Coalition. A quick note to all journalists, not just those in New England, but throughout the country who are continuing to cover this presidential election. Thank you. Many, if not all of you, are working very long hours and days trying to keep all of us informed. So to all those local journalists, please know that even though you often have a thankless job, it is in fact a crucial one to our democracy. Your work is essential. And on behalf of NEFAC, thank you for all that you do. I'm here with Gregory V. Sullivan. Greg is a longtime NEFAC board member, as well as counsel to the Union Leader in New Hampshire. Greg, thanks for joining us.
My pleasure.
Greg, over the last few years, those in New Hampshire have been hearing a lot about what's called the Laurie list. And just recently, the state Supreme Court made a decision that adds a little clarity or provides some guidance as to whether or not the public, all of us, should have access to the names on this Laurie list. Can you tell us a bit more about what the Laurie list is and why we, members of the public, should care about whether it's released?
Sure, thank you. Well, the Laurie's list, simply put, is a list now compiled by the Department of the Attorney General in New Hampshire of police officers whose departments have determined, generally the chief of police or perhaps a county sheriff, has determined that a particular officer has issues regarding that officer's trustworthiness and credibility, particularly going forward into pending criminal cases. So historically, that list has been secret, and Union Leader, the ACLU of New Hampshire, a number of other media outlets in New Hampshire joined forces, and Gilles Bissonnette from the ACLU and myself argued the case against the New Hampshire Department of Justice, seeking to make that list public. We believe the public has a right to know how their police officers are performing, whether for good or for bad. And generally, I must say, it's for good.
So before we get to your specific arguments for transparency, can you explain to us a little bit more about why the Department of Justice would like to keep this list secret? What are their arguments?
They actually made three specific arguments saying that the public did not have a right to access to this list. They cited a statute, RSA 105.13b, which we argued successfully relates only to police officers' files who are currently testifying in specific criminal cases. We felt that that did not pertain to the Laurie's list in general. And by the way, we all call it the Laurie's list, but I think in 2017, the Attorney General changed its name to be the Exculpatory Evidence Schedule, or the EES list, simply put. So their first argument was RSA 105.13b prevented disclosure of this list to the public, and the Supreme Court has now rejected that argument. Their second argument was that it was an internal personnel practice, and that had been the law in New Hampshire, that records relating to investigations of police officers were exempt from disclosure under the right to know law. From 1993, when the Supreme Court decided the case of Union Leader versus Fenneman, which we believed was decided incorrectly. And in 2020, the Supreme Court in two cases, Seacoast Newspapers versus the City of Portsmouth and Union Leader and ACLU and others versus the town of Salem, the Supreme Court finally overturned Fenneman and said that these records that we're looking for, i.e. records of police misconduct, are not to be considered exempt because they are internal personnel practices. They finally took a definition of internal personnel practices that does not relate to the EES schedule and other police misconduct files. So the Supreme Court rejected that argument that they were internal personnel practices. The Superior Court, prior to the case going to the Supreme Court, had ruled that way on those two arguments. And thirdly, the Department of Justice had argued that these were personnel files, which again are exempt under the right to know law, RSA 91A5, Roman numeral 4, which is most of the exemptions to the right to know law. So they said they were personnel files. The Superior Court rejected that argument. The Supreme Court also rejected that argument, but the last phrase of that section of the right to know law also exempts other files whose disclosure would constitute an invasion of privacy. So the two cases that I mentioned, Seacoast versus Portsmouth and Union Leader versus Salem, those two were remanded to the Superior Court for the Superior Court to conduct a balancing test to determine whether or not the public's right to know will outweigh any claimed privacy interest by the particular police officers involved. And the Laurie's List case similarly now has been remanded to the Superior Court for that same analysis. A fourth case, which was argued on the same day of the Salem and Portsmouth cases, Mary Ann Salcetti versus the City of Keene. The Keene University students were also looking for police misconduct files, and that case was remanded to the Superior Court for a determination as to whether or not the privacy interests of the police officers, excuse me, outweigh the public's right to know about the performance of these officers. It's my position in the three cases I'm involved in, Salcetti being a third, that police officers have no privacy interest with respect to the performance of their public duties. Historically, privacy interests of individuals, police officers, and everyone generally relate to intimate details of a person's life, medical issues, sexual issues, etc. Certainly not the performance of duties by a public officer. So I feel very strongly and confidently that ultimately, if these cases do go back to the Supreme Court, that the court will determine that the public has a right to know how their public officials are performing their duties, police officers included.
So let's say, for sake of discussion, that these lower courts do side for transparency and against the privacy interests of these officers. What does that mean in, I guess, more simple terms for your everyday New Hampshire citizen? Like, how can we relate what's going on here in the courts to your average citizen who maybe doesn't know much about the right to know law, and isn't as involved with the judicial system as what you just described? Why is it important to them?
Well, simply put, under New Hampshire's right to know law, every citizen has a right to request, either in writing or orally, but I always recommend in writing, any public records. And public records are broadly defined. I often jokingly say any and all things that come into your possession if you're a government employee that's not your private shopping list. So there are exemptions, and the exemptions are, for the most part, reasonable. But this has been a very tricky one, police misconduct. But I believe the time has come for the public to have the right to know how their officers are performing. And that, of course, affects all of us, every citizen in New Hampshire. And in New Hampshire, the citizenry are pretty well informed about their rights. They're very active politically and socially, civically. And for the most part, know that they have a right to go into City Hall or Town Hall or any governmental agency and request in writing records that are of interest to them. And I will say New Hampshire has an extremely strong constitution guaranteeing these rights that I'm talking about. The Constitution, specifically Part 1, Article 8, says that government at all times shall be open, accessible, and responsive to the public's right of access, which shall not be unreasonably restricted. So the issue in these cases is a restriction preventing citizens from knowing how their police officers are performing an unreasonable restriction. And of course, my position and the position of all the other litigants is that it's an unreasonable restriction. We do have the right to know. And in New Hampshire, we also have a very strong statute. We call it the Right to Know Law, RSA 91A, which again makes sure that the citizens have the right to know what their government is up to.
So now with these cases back in lower courts to balance out the interests between transparency and the privacy of law enforcement officers, how do you consider the ruling made by the state Supreme Court? Is this a victory for the public's right to know? Is it a little bit more of a mixed decision? Too early to tell? How would you describe it?
I think it's definitely the three cases that were decided or argued rather in January and decided in May, and then the EES case. I think all of them are a step in the right direction. We've removed 3 of the 4 roadblocks that the Department of Justice has been maintaining. And again, the 4th one is this balancing test. And, you know, I've done a lot of, as you know, studying on everyone's right to privacy. And there's only 4 types of wrongful invasion of privacy listed by what we call the restatement of torts. And one of them is publicity that's given to private life. And I don't even think a police officer performing his or her duties is part of their private life. But even if it were, we can't get that information if it's offensive to a reasonable person, the disclosure would be, and is not a legitimate concern to the public. And here, how the police officers are performing their duty clearly is of legitimate concern to the public.
For sure. So when do you expect us to get these lower court rulings and some finality to these cases?
Well, as you know, there's this thing going on called a pandemic, which has really crippled the courts. In New Hampshire, right to know cases do get generally expedited handling. But I wish I could tell you that, yes, we're going to be back before the Superior Court in these cases next week or next month. I really don't know that, but all the parties are continuing to, I was going to say, bombard the Superior Court with supplemental pleadings and arguments both ways.
All right. Well, let's hope for speedy decisions and fingers crossed for the public's right to know. Greg, thanks so much for taking the time to explain these cases to us and update us on the Laurie list.
Well, thank you for giving me the opportunity, Justin, and you keep up the great work.